basically all stopped.
We're not going to put up with that.
This edition of the Ridley Report is brought to you by NewHampshireFreePress.com.
So the witnesses will be sequestered. Sergeant Rivera, is he your witness?
Sorry, one and only.
All right, so he'll be sequestered once he gives his testimony.
Here we have, please, sir.
All right, so who else? Take the hat off in the back, please.
Can I raise an objection on my constitutional right?
Yeah, why don't you go out and file a motion, I'll take a look at it.
Sure. Now, you know what? I don't think I will. I think I'd rather just wear my hat, please. I have a right from the...
All right, just have a seat. We'll deal with it later.
Thank you.
Just have a seat. All right, who else is your witness? Proceeding. There is a court rule. You have to stand up when you address the court. We're going to enforce that rule as far as being a litigant here is concerned. All right, go ahead.
Call Sergeant Rivera.
Objection.
Objection to what?
I received notice of this witness 5 days prior to trial. District court rules require that this notice be given to me at least 14 days before trial.
Can you show me your rule?
Court rule 2.10c, not less than 2.10b, not less than 14 days prior to trial, the state shall provide the defendant with a list of names of witnesses, including experts and reports.
Stand up when you're addressing the court.
I apologize. Including experts and reports, and a list of any lab reports with copies thereof. And I have my notice, but it is dated July 22nd of this year. Therefore, this witness should not be allowed to testify against me.
Is this the state's response to that?
It would be the witness list went out, Your Honor. I'm not, I can't speak for the day that went out. It should have gone out. The defendant certainly is known for a long time. He's never requested a witness list, nor has he requested discovery.
Can you show me can you hand the bailiff the letter that you got?
Yep. Do you want the district court rule as well?
No, that's okay.
Okay. And the court rule does not say...
Actually, I don't have my rules in front of me here, so why don't you give them that too?
The court rule, I take note that the court rule does not say I have to provide a request for this witness list. It is to be provided.
All right, just hang on a second. You have a seat. All right, when did you actually receive the letter, Mr. Ryder?
I believe it was the day after it's been dated, or the 2 days, July 23rd and July 24th.
All right, the state asked you what?
I can't speak to why it didn't go out in a timely fashion, Your Honor, but certainly there's no prejudice flowing from Mr. Ryder's receiving it 5 days before trial.
Two things here. Can you state how you're prejudiced by not knowing about this witness? Why don't you remain seated? Can you tell me how you're prejudiced by not getting that?
I don't understand the question.
Well, I can waive court rules as justice requires, depending on the circumstances. So very often we take a look at whether or not someone feels they've actually been prejudiced by the fact that a court rule wasn't obeyed.
I understand.
So the question is, if there's something you can tell me where you think that your case is prejudiced by the fact that you didn't get notice in time, I want to give you that opportunity.
I would urge the court to follow its own rules as much as possible, unless there's an outstanding circumstance where it should not.
Well, you did have 3 or 4 days notice, is that correct?
The letter is dated July 22nd, and the court rules require that I have 14 days notice, and I got 5 days notice.
Okay. Well, the purpose of the rule is to give notice to a defendant as to who the witnesses are going to be. So again, if you want to, I'll allow him to testify unless you want to ask me to continue the case and give you an opportunity to be better prepared for the witness's testimony.
I don't want to continue the case. I want to make note that I have made sure to follow all the court rules, and you're giving a special exception to this witness.
This is not an unusual situation. I mean, you may not be well experienced with it. This is not an unusual situation. Again, I give you the opportunity if you want to have an extra opportunity to prepare because you say you weren't aware of this particular witness's testimony, then you have that chance. So it's either we go forward today or you have a chance to be prepared.
Go ahead and go forward, I guess. I made sure to submit all my paperwork.
I'm noting your objection, and depending how the case goes, if it goes against you and you want to appeal it, that'll be something you can take up on appeal as well.
My name is Ridley Report, Rivera. I'm a member of the Keene Police Department. I've been with the police department for 17 years.
Were you here handling an arraignment involving a Dave Ridley?
Yes, I was.
And is Mr. Ridley, to the best of your knowledge, associated with the Free State?
Objection, leading question. Objection, leading question.
What's the response?
It's background information.
Overruled.
And we actually had to bring the court to a halt because of the disturbance out in the lobby. We had juvenile matters that were going on that had to be basically all stopped.
All right. We're not going to put up with that. This is an important case for Mr. Ryder and for everybody else here. You may not agree with the testimony, but I'm not going to put up with that kind of behavior from the people in the audience. You would have to be removed. Right now,
With a loudspeaker out there in the street. In the street.
all right. Well. We'll take a recess until it stops.
All right. All right.
Thank you. Have a seat.
Surprisingly enough, the lobby was starting to clear, and there was just a handful of people left in the lobby until another individual, Nicholas Krause, turned around and said out loud that he was not leaving, and he decided to sit down on the floor.
Hang on a second. We're going to continue the trial in the other room. Anybody in the audience can watch on television. You can bring your camera in.
Can I object?
You can object.
I object.
Okay. Well, that's where the trial's going to continue in there because we can't. Obviously, it's too disruptive to try to do it in here. All right. We're back on the record here. The court wants to put on the record a couple of things. First of all, when the court first entered the main courtroom, because we're continuing the case of State versus Nicholas Ryder, 092728, in the conference room, reluctantly, because a number of things that happened. First of all, though the court ignored it, the court needs to put on the record that most of the audience did not stand when the court entered the courtroom. The court ignored that, as indicated. The number of people in the audience did stand, however, when the defendant was introduced, which the court found disruptive but took no action at that particular point. On a couple of occasions during the testimony, most of the audience was not quite taking it seriously, and the court noted a good deal of laughter in the audience, and the court had to make a comment about that. During the trial, and what was clearly an orchestrated effort to disrupt the court proceedings, the court had to take a recess in order to deal with the fact that there was extra noise coming from the outside. And then when we tried to resume the case, when another name was mentioned, it was a smattering of applause in the audience. A fair trial applies to both the defendant and to the state, and the court cannot conduct a hearing in the open courtroom based under those circumstances. It's clearly disruptive. Clearly there's an intent to disrupt the court and be disrespectful to the rules of the court, so we have to reluctantly continue the case in here.
NewHampshireFreePress.com. The libertarian paper cranking out great news and opinion since early 2006. NewHampshireFreePress.com.